Your hometown news and information station.
Welcome back. I'm Vince Perryman, and you're watching Legalese. Joining us on our show today is attorney Wayne Mink of Dinkelspiel, Rasmussen, and Mink. We're discussing homeowners associations. Before the break, we covered, sort of what they are and how they come about. Now, what is it exactly that the homeowners do?
That's a great question, and I get that a lot of times when I attend meetings. In theory, there are common elements to the development, whether it be a gate, a private road, a park, a pool house, what have you, that needs to be taken care of. And what the association there is to do is to ensure that that is properly taken care of. Additionally, the association is situated in such a way to enforce the covenants. Now, a great question is what a covenant? A covenant is basically a restriction on your use of the property. You covenant, you promise that you're not going to do X. So a set of covenants, conditions, or restrictions, or a master deed is going to provide a set of restrictions on your use of the property. And they range from the common sense that you're not going to run a chicken coop or, dog kennel in your yard to really difficult ones to deal with, such as parking regulations. And parking regulations are a big area of contention in this area of law. But that's what they're designed to do.
Okay, now, a lot of times you'll live in an area that doesn't necessarily have a homeowners association, but you'll get some sort of neighborhood association newsletter. So with this, when you're dealing with an actual homeowners association, it's something where you've got a fee assessment, right?
Yes. When you just have a neighborhood association that's putting out a newsletter, or as I said earlier, like a directory, that is not a formal homeowners association in the legal sense. Now, that's just an association of homeowners that want to do something. Maybe they have a neighborhood watch or something along those lines. That's great. That's great community involvement. But they don't have fee assessments, and they don't necessarily have the right to enforce certain restrictions on the use of property. Now, the fee assessments are in place to take care of the common areas. Again, let's go back and say you have a pool in your development, like some of the newer developments in Germantown have. Well, someone has to pay for the chemicals to go into it. Someone has to pay to open it. Someone has to pay to close it. Someone has to pay to operate it. And the means to do that is to assess the individual homeowners through the association. Those assessments are set by the board of directors on an annual basis and then allocated amongst the homeowners, either on a pro rata basis, if it's like a condominium based upon your percentage of square footage over the total, or on a per lot basis. So if you've got 20 lots in a development, you get 1/20th the assessment. The assessments can either be done annually, quarterly, bi-monthly, monthly. It really doesn't matter. But what happens is you get assessed on an annual basis as to what your total charge is going to be for that year. Now, that's what you would call regular assessments. Some of these developments have the right for special assessments, and depending upon the development, there might be some restrictions on how that works. And then there's some associations that can do emergency assessments. Let's say someone drives into a wall and they need to fix it. That's an emergency assessment, and the documents will provide a guideline as to how you address that situation.
Okay. And I guess with that too, so what's the ramification if I get this bill from a homeowners association and I say, I don't want to pay that?
You don't want to take that. The problem is, given the way the economy is right now, and I don't like blaming things on the economy, homeowners association collections is growing exponentially. The homeowners association is one of the few true growth areas in law, but collections is just taken off. To give you an idea, earlier this past decade, we probably did maybe a couple hundred collections a year at my law firm. Last year, we were around 4,000. And the theory is that if you're buying a house and you have a mortgage and you have real estate taxes and you have homeowners assessments, you're going to pay your mortgage first, because if you don't, they're going to foreclose. You're going to pay your taxes second, because you don't want to lose your property to a tax sale. So if you're in a hard economic situation, your homeowners assessments are the last to get paid. What people don't understand is that the homeowners association has a legal right to enforce that. Again, the documents that govern that association, whether they're covenants, conditions, or restrictions, master deed, or a declaration of condominium, will provide that that association has the legal right to sue you, to file a lien against your property, and in some instances do what's called a non-judicial foreclosure, which means they can basically take your property away.
And then too, there are some master deeds that also have that lovely attorney's fee provision in there, to where you get hit on top of that with the assessments too.
Right. Tennessee is one of the states that says that unless attorney's fees are specifically in there, you're not supposed to get them. There's at least one court case, I believe in the Eastern District of Tennessee, that says that unless a covenant's condition of restriction specifically provides for attorney's fees, let's say it says costs or expenses of collection, that doesn't include attorney's fees. So you need to be careful about what these documents say, and what a lot of associations are doing now is approaching my firm to address that situation, because they don't want to be in a situation where they have to collect and then they have to pay the attorney, because that's a difficult situation to be in economically for the association.
Right. So as far as these documents that govern, they can be amended?
Yes, they can.
Okay.
The document's going to provide how that works. Traditionally, it's going to take a supermajority, usually 2/3, 67%, 75% of the owners to do that. And you're going to have to look at your individual document to determine precisely how that's done. Some just require a vote at a special meeting. Some require that the document be signed by a percentage of the homeowners. Obviously, that provides some logistical hurdles to be addressed with. Now, from representing the homeowners association side, one of the things that we have to do is ensure that if a board comes to us that wants to amend a document, that we give them the logistical means to do so. So we've developed some documents to provide to homeowners to aid in that, to overcome those logistical hurdles. But amending a document is a very serious endeavor, and I would not advise people that aren't trained in law to do it, because traditionally they mess things up.
Right. And yeah, it's one of those things that when you start to look at different changes, and I mean, it's one of those that when you draft the initial document, there's no real, you don't know the unknown. Yeah,
a good draftsman should probably walk the development with the developer before doing any work. You need to, and I've drafted some of these documents, and I'll say my work's not perfect, but what I try and do is go out, find out what's being put in. For example, in one of the developments I did was condominium project. It had 2 buildings, all right? Elevators in each building. Well, let's say the elevator in building A broke down. Well, the people in building B don't care. So why should they be assessed to prepare that in building A? So we address that situation in the document so that the people that are impacted pay the right fees.
Okay. When we return from our break, we'll talk more with Wayne Mink about homeowners associations. Please stay with us.